Sorry to interrupt, you're muted.
Good afternoon. This is Ronell Nolan, President, CEO, Health Agents for America, and would like to welcome you to this very important webinar that just couldn't come or be scheduled at the more perfect time. I'm going to continue to let folks in, but I wanted to just give you a little bit of update about who HAFA is. Some of you are HAFA members and some of you are not. As you can see from the photos, we're very involved on Capitol Hill. But we represent independent agents exclusively. We currently have members in all 50 states. November will be our 10-year anniversary, so we're still definitely in our infancy, but we are growing daily. Got a few I'm gonna let in while I'm chatting. We fight for commissions. That's not a scary word to us. We continue to fight 24/7 for a fair wage to make sure that agents and brokers are paid for the hard work that you do. For only $18 a month, that's the lowest membership, you can join HAFA. Very easy. You go to our website and you click on membership. I am very honored to have Angie Sura speak to us today about the family glitch. She is one that is very involved, always has her finger on the pulse, and just wanted to give you a little bit of update about her. Not only is she a HAFA member, she was our first HAFA chairwoman of the board that was from outside of Louisiana. She is from Pennsylvania. So Louisiana, we started HAFA in Louisiana. Quickly, we moved to other states, and Angie was our first chairwoman of the board from out of Louisiana. She started her career in 1997. She maintains her license in Pennsylvania and New York. And she's a very, very interesting person. And she speaks at the HAFA conference, so I encourage you to come and speak to her. Currently, she is the Senior Director of Compliance and Technology for Navigate HCR. She speaks all over the United States. She has a background, I believe, in something to do with the FBI. I just know that she can she can find anything on your computer that you might be missing. So she's a very, very cool individual. And without further ado, I'm gonna, and this is CE and CE approved, and Angie will be talking about that as she goes. But I would like to turn it over to Angie. And let me give you the opportunity to share your screen.
Perfect.
And I believe it says you can share.
I can. Let's just make sure that comes up. All right. Well, thank you so much for having me, Ronell. As always, it is
I think I'm still seeing my screen, Angie.
Oh, you are? Let me try again. One sec.
There we go.
Okay, excellent. Thank you. Nothing like a little technical difficulties. But again, thanks, Ronell, for having me. You are right. We were just talking about this before we were letting everyone into the webinar. Your foresight into scheduling this second event couldn't have come at a better time, which we'll talk about here shortly. As Ronell mentioned, I'm Angie Sura. Actually currently Vice President of Compliance, Managing Director at Navigate HCR. I don't have anything to do with the FBI. I just happen to have a master's degree in criminal justice, but Ronell likes to embellish that. Before we dig in, I've got to drop my disclaimer. I am not an attorney, although sometimes I play one on TV. I'm not doing that today. So just to be aware, this content is not meant to provide any specific legal or tax advice. Should you need that kind of special information, please contact your attorney or CPA. Also, please note the presentation and recordings may not be reproduced without our permission. As Ronell mentioned, this is good for 1 hour of CE. You must be on for the whole hour. The very end, we will provide the information that is needed in order to send into the proper state your information for CE. So let's dig in. So I would be remiss if I didn't begin the presentation by talking about the basis of the Affordable Care Act that was passed all the way back in 2010. I cannot believe it has been that long, and I still talk about it, I think, every single day, because it's still at the top of mind. It's still super relevant. But really the key points of the Affordable Care Act were to make health insurance available and affordable to more people in America. Now, it's done a lot of other things, or it was meant to do a lot of other things. This is not a political discussion. This is the law of the land, so we must abide by it. Our goal is to educate on it. We know that the original goal was to expand Medicaid, to give some lower income folks the opportunity for help with their health insurance, because as we know, year after year after year, the cost of health insurance goes up. It also set the standards for what type of coverage needed to be included in order to be considered ACA compliant. Employers had a big piece in this. For employer-sponsored coverage, has to contain certain provisions. Employers with 50 or more full-time equivalents must offer benefits to their benefit eligible population. Certainly, there are a lot of different notices that have to be delivered annually. We've got the health insurance exchanges, which originally most all the states were in the federal marketplace. Since 2010, we've had a lot of states come out with their own state exchange. They're still very similar, just a little bit of a different look and feel. And of course, failure to comply with the Affordable Care Act comes with ridiculously high penalties. Now, in 2019, the individual mandate penalty was reduced to 0. Nothing has changed for employers other than the penalties keep going up and keep growing every single year. Well, despite all of this, there's still roughly 26 million people lacking health insurance coverage, which is about 8% of the population is still uninsured. We've found this term, the family glitch, being talked about quite a bit. And actually, believe it or not, this isn't the first year that it's been talked about. But it got a lot of press because on April 5th, President Biden announced a proposed regulatory fix to what is known as the ACA family glitch. Excuse me. So the original interpretation of the law, which was clarified by the IRS in 2013, was that if an employee is offered benefits from their employer, if those benefits tick off all of the compliance boxes, meaning it offers minimum essential coverage at minimum value and is affordable based on whatever the current year's affordability percentage is, then that makes it a qualifying offer. The glitch is it makes it a qualifying offer for the employee and their family members that are in the household. Now, the problem is, for those of you who are frequent flyers in assisting folks on the individual marketplace, you know that the individual marketplace is asking for household income. Well, that's great. And that's how the individual marketplace works. The problem is on the employer side of the fence, the employer doesn't ask about household income. They don't care about household income. Their responsibility to be compliant with the Affordable Care Act is that it's affordable for the employee, for employee only coverage, okay? Employers only need to calculate affordability based on employees' income. regardless, the original interpretation, again, which was clarified in 2013, said it doesn't matter. If the employer is making a qualifying offer, then that offer is extended to the family. Well, that's where the glitch happens, because if we look at someone's entire household income versus the employer just looking at the employee only income, the family itself minus the employee could actually qualify for a tax credit depending on what their income is. But because of this glitch, and that this interpretation has been in effect since inception of the Affordable Care Act, it's estimated that over 5 million people fall into this glitch. You know, the other aspect of the employer's responsibilities is the employer has no responsibility or no requirement to contribute at all towards adding a spouse, adding spouse independence, just adding the dependents. The employer's only obligation is to the employee. So it's very common for an employee to get their offer. They have a smaller contribution. It's affordable, all is well. But it's shocking when the employee sees how much more they'd have to have withheld from their pay to cover the cost for spouse and children. So I wanted to put this into an example. I like examples. I feel like it ties things together a little better. So let's go through an example. Let's have our assumption family of 4. We've got an employee, a spouse, and 2 children. Now the employee is deemed benefit eligible, and they are offered insurance through their employer. Their employer has an employer-sponsored health plan. That plan ticks off all the boxes, provides minimum essential coverage at minimum value, and is affordable. So let's assume in our example, the employee only coverage is a total cost of $600 per month. The employer is going to contribute $400 a month. The employee's contribution is only $200 a month. Now, let's assume in our example that the employee's hourly rate of pay is $25 per hour. So if I take $25 per hour times 130 hours, which is our safe harbor, that comes to an affordability calculation of $312.33. Now that calculation is based on 2022 affordability percentage of 9.61%. Now what that means is an employer cannot charge an employee more than 9.61% of their income towards their health insurance benefits. Okay, now that's for the lowest cost plan, employee only. The calculation is based on the employee's wages. So if affordability is $312.33, but the employer's only charging the employee $200, they're absolutely affordable. The employer has done exactly what they are required to do. They've actually done it even a little better. That employee contribution is less. Perfect. Based on this information, even though it would cost a total of $1,800 a month for the employee, their spouse, and their 2 children, the employer, again, is only contributing $400. Add in the employee's $200. The employee would have to pay $1,400 a month. And that's still okay. It's still considered affordable. This is the glitch, folks. $1,400 a month is not really affordable, but because of the interpretation of the law, it's deemed affordable. Therefore, this employee, their spouse and kids cannot go out into the individual marketplace and possibly receive a tax credit. This is the glitch. This is where that estimated 5 million individuals are sitting. And so what we have seen over the years is a family like this, a family of four, may have no other choice but to pay that exorbitant amount. Granted, it's pre-tax if it's being withheld from payroll, but it's still an exorbitant amount. That's the glitch. Now, let's add to our assumption here. Let's assume that the spouse of this employee also makes $25 an hour. Even in that situation, it would still be considered unaffordable if we were plugging all of that into the marketplace. The problem is there's no point plugging it into the individual marketplace because of the qualifying offer. Now, based on the 2023 change, remember, President Biden announced this fix back in April. The intent was to have this resolved prior to the beginning of the 2023 open enrollment period on the marketplace, which begins in November. So based on this change or reinterpretation of the law, in our example, the spouse and children could now go out to the individual marketplace and probably qualify for a subsidy cost sharing out there. Now, the employee still would not qualify. The employee is still receiving their own qualifying offer from the employer. What this change is doing is just reinterpreting the law to allow these family members to go out to the exchange, plug in their information, and possibly receive a tax credit. Now, there have been other legislative efforts to fix this over the years. Now, we had Senator Al Franken's Family Coverage Act in 2017. Hillary Clinton certainly proposed this during her 2016 electoral campaign. And then, of course, President Biden brought this out April 5th of 2022. We will be sharing these slides later. You're welcome to go take a look at any of the links that I have enclosed in here for your viewing pleasure. But folks, it is official. And I said earlier, you know, Ronell, we got together and we did a presentation several weeks ago, the same thing, kind of leading up to what was anticipated to happen. And Ronell said, you know what, can we go ahead and just get it on the books to schedule another one in October? And I said, sure, let's do it. Well, by golly, it was 2 days ago that we were able to pull from the Federal Register the reality of this, that it is official. It's going to happen for 2023. So let's dig in. You can absolutely download, and again, I'm going to have the links here. You can download the 86 pages of this. It's a very, very interesting read. You know, there were over 3,800 public comments made when this was first posted back in April. And in that 86 pages that you can download now and read, it talks about how they reviewed the public comments, why they may have chosen to say, well, we can't do anything about this particular aspect, or another aspect can't be amended via executive order. It's something that would have to be amended with some sort of additional legislation. So I think it was a fabulously interesting reading. I highly recommend that you do it. This slide and the next slide, I've got a handful of excerpts that I copied and pasted right out of that PDF that, again, is public out on the Federal Register, because I thought it was interesting. And without any actual guidance from any of the powers that be yet, which we're expecting Department of Labor guidance, HHS guidance. I mean, there's a lot of guidance that needs to come out. What I pulled out as excerpts are areas that I think offer some initial guidance, and some are just interesting. So the first one that I highlighted was one married couple had actually testified to the state legislature in Maine and said that they divorced solely to retain the husband's eligibility for a premium tax credit after his wife got a new job, with an offer of family coverage at a cost of $16,000, which was over half of the husband's income. This is a perfect example of a husband and wife situation where they were affected by this glitch. Now, one thing that I thought was very interesting to cover here, and I pulled this right out of the excerpt, is the cost of covering individuals who are offered the coverage but are non-family members is not considered now in determining whether the employee's family members have an offer of affordable employer coverage or not. So a non-family member would be, with the passage of the Affordable Care Act, you can keep your children on your employer-sponsored benefits until the month after they turn 26 years old. Well, 26 years old, I mean, they're not kids anymore, right? My goodness, my youngest is 21. He is a married man who is stationed in another country as an active duty Marine. He is a grown up, but technically I could keep him on my employer sponsored benefits. I mean, I can't because he has military coverage now, but in that kind of situation, it's common for a dependent over the age of 21 to have their own life, their own job, be married, all of those fun things, but we're still able to keep them on a parent's benefits if possible. So it'll be important when we're looking at the non-family member situation, and I really look forward to additional guidance on this, especially for the concept of the children over the age of 21, but under the age of 26. Now, the proposed regulations do not change the affordability rules for employer and employees. The affordability rule for employees is, very specifically laid out and provided. I've got the particular section referenced here. This is something that even if they wanted to, they couldn't change by order. It would have to be by some other type of legislation being passed. So despite that, this is a lot of new information, a lot of moving parts. Employers who must provide benefits to their employees, the way they've been dealing with that for the last 12 years remains status quo. That isn't changing at this point. Now it's interesting, so far, the proposed regulations that again are out there and official and going to start here for January 1st, 2023, it doesn't address anything regarding affordability rules related to individual coverage HRAs. They don't address it at all. So essentially what they're saying is the current rules in place for ICHRAs are going to remain unchanged. They didn't address the QSARAs either, but it'll be interesting to see if any additional guidance comes out. But at this point, it's not addressed. So how we calculate affordability as an employer when we're offering individual coverage HRAs, that will remain as it has been. Now, certainly the department and the Internal Revenue Service and HHS, they're tasking HHS to really help with the implementation efforts. HHS is going to have to work really quickly. I'm assuming they've been working already on this since the president talked about it all the way back in April, but the exchange applications are going to have to be revised. Resources are going to have to be made available. Other kinds of technical assistance, education. There will most likely be another education module for agents and brokers that they're going to have to go through to make sure they're clear on the rules of this change, so that when it's time to assist people out there in the individual marketplace, that you're up to speed and ready to talk through it, because there are going to be some other interesting pieces here I hope will let you know and give you a little bit of reassurance that everybody and their brother cannot just converge on the marketplace for January 1st. We've got some other rules that we're going to talk about here. Now, although there's a lot of work that needs to be done by the various governmental entities, this is to be in place and ready to rock and roll when open enrollment for 2023 opens up shortly here, coming in November. We as agents have a very critical and important role ahead of us to assist these clients, these individuals, with something that is brand new, a brand new interpretation of a law that's 12 years old. We're going to be critical in the path of assisting these folks. And again, remember, we're talking about potentially 5 million people out there. We're going to be critical in this role to make sure we're there to assist and provide education and support and helping them get their benefits in place, or at least know their options at this point. So at this point, what they're anticipating is some of the revisions. They're going to include, obviously, new questions on the application. Obviously, that's going to be critical. New questions about employer coverage offers for family members. Now, this is really where I'm going to make the educated assumption that employers are going to have to be diligent in providing their employees with comprehensive open enrollment materials that state this is what the cost would be to add a spouse. This is what the cost would be to add one child, multiple children, spouse and children. Individuals are going to need those calculations and that information to take when they're filling out their application. So a little nugget for you all to put in your kind of toolkit of what do I need to let people know to be prepared to bring to the meeting in advance. That's one of them, okay? We're going to absolutely need revised materials that we can share with our clients, that the marketplaces can share with consumers, and other information like that. This area is already confusing to the general public. This doesn't do anything but probably complicate it more, but it's a great thing, and we need to be prepared as agents to get them through that and to talk through it. Certainly HHS is working regularly with the state exchanges because those need to be updated as well and make sure all the new rules are implemented. Certainly, again, HHS is going to provide training on these new rules to agents and brokers. So be watching for that. I'm sure you've already gone through your annual open enrollment training for the marketplaces. Watch for the email to come that's to tell you when the next new updated module is coming out, because you more than likely will have to take something before open enrollment season hits. This I thought was interesting, that HHS is considering outreach to specific consumers who had applied through the federal exchange in the past and had been denied, basically been denied because there was an employer offer out there from, somebody in the family. So they're evaluating whether or not they want to do any kind of direct outreach to these individuals. Would be probably a great practice for you to go through your records from prior years. Now, granted, that particular client of yours or prospect of yours, something may have changed in their life, in their household, whatever, that it won't matter, but it won't hurt to go back through the records and preemptively reach out to those folks. We're the experts in the business. I'm sure they would appreciate you reaching out and saying, hey, this is something new that we want to talk about and see if it's applicable to you. Now, interestingly enough, what the estimated cost to the federal government is going to look like is $3.8 billion per year over the next 10 years. Consequently, and I believe I mentioned this in the last presentation, consequently, the recent passage of the Inflation Reduction Act contained an excerpt where the Internal Revenue Service is being infused with $45 billion, a chunk of that, a large chunk of that, being earmarked for enforcement efforts. What does that mean? Well, in anticipation, more than likely, of this correction or change or reinterpretation going to be causing $38 billion over the next 10 years, where else can the government look at potentially recouping some of that? Well, they want to ramp up enforcement efforts in a variety of areas. Now, in what I do every single day, I deal with IRS audits practically every single day. The audits I deal with are all around the Affordable Care Act. I see audits that are a couple $1,000s owed, very seldom. Mostly they're around at least $15,000. Highest I've seen was over $14 million. We are already seeing the IRS getting far more aggressive on their ACA audits. This is letter 5699, the phishing letter that says, hey, you look like you should have filed, Mr. Employer, but we don't see that you did. Should you have? Or the 226J. The 226J is triggered when an individual, when an employee goes out into the individual marketplace and receives a tax credit. This is going to, and they list on their application who their employer is. This is going to ping pong back from the marketplace to the IRS. Now, the rules state that anytime an employee, they have to list that on their application. Anytime they're getting a tax credit from the individual marketplace, the marketplaces are to send a letter to the employer. I know for a fact that that doesn't always happen. So sometimes an employer has no idea. They have no way to step in and say, okay, well, yeah, that's great. This is a part-time employee. They absolutely deserve to go out and get a tax credit or whatever. Or they can say, yeah, this could be an educational moment where the employer can say, oh, hey, employee, we offered you benefits and they are compliant. You waived coverage. Technically, you're not eligible and you're probably going to have to pay that tax credit back when you do your income taxes. Sometimes employers never know until 2-3 years later when they get that audit. Just a couple of weeks ago, a group that we had worked with to support them on an old 2015 audit that they received. They received it a couple of years ago. We assisted them in responding to it. They sent it in, all was great. And out of the blue, a couple of weeks ago, they received another inquiry from the IRS fighting back, like fighting the response, which the response was on point. The IRS is getting more aggressive. The bottom line, they're going to want far more due diligence, more documentation in order for an employer to prove their case that they don't owe a penalty. Now, the other thing is the exchanges are most likely going to basically show two different types of affordability determination. It'll be interesting to see how that shakes out, how quickly the exchanges get their technology up to speed, because again, this isn't paper. This is technology that has a series of business logic, rules, and algorithms. So they have a very short window of time. Now, obviously, there are absolute benefits in fixing this glitch. I'm truly surprised it's taken this long to actually deal with it, but it is here, and in sometimes typical fashion, we have a very short window of time to get up to speed and get ready to rock and roll with this. But it is truly going to potentially open up affordable coverage for a lot of folks who didn't have the availability before because of the interpretation of a qualifying offer. Now, again, the IRS does not expect any new administrative costs for employers, basically because the final regulations are not, really imposing any kind of new reporting requirements, which surprises me. I really thought there would be some sort of additional requirements reporting wise, like to list what the contribution would be for, family coverage. But at this point, they're saying no. At this point, we're going to work with status quo in 2023 when it's time for 2023 reporting. Now, if something changes, absolutely we'll let you know, but employers should be ready to follow the traditional status quo, which is awesome. Same type of calculation on affordability, same information being reported on the 1095 forms. No additional new elements are being brought in here. Now, this is an interesting piece, and this is why you can have a little bit of comfort that not everybody, not all 5 million people are going to try to flood the marketplace, although they may try. Not every single person is going to be able to get into this January 1st, and here's why. We've got to be cognizant of the plans, the employer plans that are a non-calendar year plan. If, let's say, for example, I am on my spouse's benefits. His benefits renew every July. I'm enrolled with him. He's paying all the additional money. And I get excited, like, okay, great. Now I can maybe go out and get a tax credit for myself because I don't have my own employer sponsored plan. And my husband has to pay the full difference to have me on there. Well, the problem is we've got to be aware of Section 125 cafeteria rules. Technically, in order for me to be able to try to get involved in this, I have to wait until the end of my husband's current benefit plan year. Now, if his benefit plan ran on a calendar year, January through December, then yeah, absolutely. I can take a look at potentially getting a tax credit and having my own individual coverage for January 1st. Same rules are going to apply though when it comes to the non-calendar year plan and those Section 125 rules, unless there is a qualifying event to allow us to make the change, like having a child or, whatever the qualifying events are. I'm not going to list them all here in the essence of time, but know that this does not open everybody up for a 1/1 effective date, not if they're already enrolled on an employer plan with their spouse or whatever that's on a non-calendar year plan. We've still got to follow other IRS rules. And in this case, it would be the Section 125 rules. I see that the chat box is filling up. I'm sure you're watching it run out. Please know I'm almost done, and I'm going to go take a look at questions if Ronell hasn't already answered them for you. So what are the implications here for brokers? Well, obviously, we're going to have less spouse and dependent participation in group plans. As brokers, we've got to be ready to talk about the Section 125 rules here. We're absolutely going to see more participation in the individual marketplace. So for my broker friends on the line, if you're not doing individual benefits, now may be a great time to get involved in it and be there to support. If all you do is group benefits, that's great. But on the other side, if all you do is group benefits, know that your group's employees are going to be asking these questions, and you can absolutely be a resource to help them, to help educating them. Deeper conversations. If you're in the group market, you need to be prepared to have some really comprehensive conversations with your employer clients. They need to be aware of what this means so that they're armed with enough information, or at least your contact information, to give to their employees. Help them out by preparing until the powers that be give us specific model notices or guidance. Prepare some pieces to give them a little bit of education, or at least enough information about what we know today, with the caveat that as soon as more information is available, we'll let you know. And certainly, mitigate any potential overactive questions if you have groups that are on those non-calendar year plans, that they don't, their employees, dependents don't have to get all in a tither or worry right now if it's a non-calendar year plan. But education is key. I say that all the time. Any of you that have heard me speak know that I am just a huge proponent of education. I love to be educated. I love to give education. And I think education just empowers people. So as a broker, you are in the perfect position to educate your clients, your prospects, all your folks about what this family glitch fix is all about. Remember, keep a close eye on information to come out to you as a broker for another educational training module that you have to go through because of this. I have no clue when it's going to come out. I checked yesterday as I was reading through the 86 pages. I haven't seen really anything yet out there on CMS or HHS or anything. I expect that exchange notice, that piece that's supposed to go to employees within the first 14 days of hire, I expect that to get an overhaul because of this reinterpretation and change in the law. So absolutely, HOFA is your one-stop resource. If you need help crafting this education, please reach out to Ronell. Being able to provide something to your clients, to your prospects, is going to be critical. And again, that's why we are the experts in the insurance industry. So let's get it out there. Let's get the word out there and start supporting people. Some other action items. Absolutely. Keep an eye out for additional guidance. Certainly Ronell and I are going to be keeping an eye out on anything that hits as far as guidance, as far as model notices. I'm sure with something this big, and I consider this a large change, there will most likely be some sort of employee communication piece that will be drafted that can be easily downloaded and distributed to employees. That same type of information is going to be out there for individuals. You'll be able to go out there and download those pieces and be armed with them. I mean, certainly we can create what is needed in the interim, but I absolutely predict that something will be available that can be downloaded. And more than likely, there may be a requirement to distribute to employees for your groups out there. Again, I'm going to say this 100 times. Keep an eye on your email. Watch for when they kick out the module that you have to take as an agent and broker in order to do business in the individual marketplace. And, be ready to provide education to your clients, your prospects, your employer groups, their employees. If you've already done some open enrollment meetings, or you're planning your open enrollment meetings now for those January 1st renewals for the group market, you're going to have to go back to the drawing board for a minute and make sure you're adding to that open enrollment toolkit this information so that they're prepared. Now, if you do not work in the individual marketplace, that's fine. If all you do is group, that's fine. Reach out to Ronell. She can certainly assist you in finding a broker in your area that maybe can help you. or you can refer to those folks that need assistance on the individual marketplace. You know, we are a group of awesome people. We want to help. We want to help each other. I've said that from day one with HAFA. The members that I get to interact with regularly, we are helpers of each other. And again, do not forget about these Section 125 rules. I anticipate people are going to try to flood the marketplace for a January 1st policy, which means sometime in November, they're going to start knocking on our doors and wanting to talk about this. That's got to be one of the first questions. Are you already enrolled in your spouse's plan that they have through their employer, or your significant other's plan, however it works? Are you already enrolled on an employer sponsored plan because someone in your household is an employee somewhere? And if they say yes, great. We need to know, when does that benefit plan renew again? And if they say anything other than January 1st, then you're going to have to let them know they're going to have to wait, reach out to you 30 to 45 days prior to that renewal so that you can help them dig in to whether the individual marketplace would work for them, maybe give them a tax credit, things like that. So be mindful of those non-calendar year plans. The 86 pages, I've got the link here. Again, we will send you a copy of the slide deck. Go out there and read it. It's quite interesting and I think very important. Now, before I dig into the questions, I'm going to leave this up for a minute. In order to get C credits for our training today, we've got it approved for the states listed here. You're going to need to email Ronell, and you're going to have to email her with the following information: your name, your insurance license number, the state you're licensed in, your full mailing address, and your email address. Okay, I'm going to leave this up for a bit. And Ronell, there are a lot of things going on in the chat box.
Look, there's a ton that you need to cover, and I just want to say a few things. Number one, somebody just said you're the bomb, and absolutely you're the bomb. Rock star queen, I love you so much. But I wanted to say a couple of things. I have a meeting with CMS tomorrow.
Yes, I knew you would.
Yeah, one of my call items, menu items, will be what's going on with the exchange, what can we expect, when that's going to happen, and when will our training start. So if you're a HAFA member, that will be in our Monday morning news, so make sure to pay attention, because I will know tomorrow afternoon. The other thing is, if you want my hair to catch on fire, then don't work in the individual market, and tell that individual person, that family, spouse, to go to healthcare.gov or use a navigator. If you want my hair to catch on fire, and it catches on fire daily, do that. If you care about our industry and you want our industry to survive, then you find yourself a partner. And if you can't find a partner, then you ask me. We have agents working in the individual field that would love to help you, but we cannot afford to let CMS, HHS, the navigators, or anybody else take our business. We deserve it. And we can't let it go. Now, you have a ton of things to answer, Angie, so I'm gonna let you go.
Oh my gosh, I'm not sure where to start, but I'm going to try to hit as many as possible. I think, Ronell, after the meeting is over, you can probably get all the chat, and if you want to kick them over to me, I can answer them. I'm going to do my best. Let me scroll all the way at the beginning and see what I can find here. Oh my gosh, I'm never going to get through all these in 10 minutes. Let's see here. What about this? Husband has his own coverage through his employer. Wife gets her coverage through her employer. Can we still check for coverage for children only if their total annual income is too low to afford children's insurance, or would they automatically be qualified for CHIP? This is a great question. Yes, you want to take a look at whether or not they could qualify for CHIP, because that's going to open up some room in the CHIP world. And I think if you go out into the individual marketplace, or wherever you go to look at, the children's health insurance plan, I wouldn't do it today. It's probably not going to be available by any means today, but I think there are going to be some updates to those kind of qualifications as well. So yeah, we're going to absolutely see more children getting into CHIP. Affordability calculation one more time. Affordability is employees' rate of pay times 130 hours times the current affordability percentage. Keep in mind, 2022 is 9.61%. 2023, it's going all the way down to 9.12. Let's see. Gosh, there's so many. Oh, yes. Thanks, Junie. Rate is 9.12, historic lowest ever. Non-calendar year plans. What do my clients do until January? Okay, so if you have a client that has a July benefit renewal date in the group market, their status quo until we get closer to July. If they're having the employee contributions withheld pre-tax. It's all about whether it's a cafeteria plan involved. Most of the time, yes, it's pre-tax, and we've got, to deal with that. No, 9.12 for the entire family. No, it is not 9.12 for the entire family. In the group space, it's 9.12 for the employee. I believe, and Ronell, keep me honest here, was it the Consolidated Appropriations Act or the recent Inflation Reduction Act? Something allowed for the lower percentage out in the marketplace to be extended. Remember, it was decreased to 8 point something in the individual space because of COVID, but it's still out there, right? They extended it longer.
Yeah, they extended it. So the over 400% of poverty and all that's still included.
Mm-hmm.
And I think it was in the CAA, but I could be.
Yeah,
wrong.
I can't remember either.
Yeah.
Are all group health plans run on a Section 125? Well, here's the funny story about that, because I'm in compliance, every day, 24/7. A lot of employers know to pre-tax certain withholdings. What they don't necessarily know is, in order to do that legally and officially, they need to have Section 125 plan in place, meaning documented, meaning they're doing Section 125 non-discrim testing every year, unless they qualify for a simple cafeteria plan. So at the end of the day, are they withholding pre-tax? And if they are, and you're in the group market, it'd be a super great question to ask. Do you have a Section 125 plan document in place? What are the chances the court slams on the brakes on this? Oh, it's a great chance that's going to happen. We are going to see people pushing through some stuff on this in the court system. Absolutely. But some of the big houses, like the American Medical Association, AHIP. I mean, there's some big contenders out there that are fully in support of this. So we'll have to see what happens. Anything is subject to potential litigation. Yes.
Angie, this is a good question. What if the spouse and children are not covered on the employer plan? They chose not to, they couldn't afford it. Do they have to wait to open enrollment? Or since they don't have coverage, it's effective January 1, can they enroll January 1?
Yes, they can. They can.
That's huge. That's huge.
That is huge. Yes. Let's see. Oh my gosh, there's so many. Ronell, any other good ones you want to pick out as I'm trying to scroll through these?
Joel says, what's the percentage for the family rate for 2023 if it is not 9.12? It is 9.12. That's the affordability factor, right?
9.12 is the affordability factor for employee only. That's what the employer must do. On the exchange, on the individual marketplace, I don't know what it is for 2023, actually. If it's another year going to be in the 8s, or if it's not, then it will match. It will be 9.12.
Yeah,
You'd
and
have
on
to
the
look back at.
marketplace, it'll depend on their federal poverty level. And
Mhm.
if it's a Medicaid expansion state, it'll be 138. And if
Yeah.
it's not, it'll be 150.
Yep. Please inform us if groups are not a calendar year plan, that when the group renews, example, March 1st, will that be considered a special enrollment period? Yeah, I believe it will. I believe it will. It'll be interesting to see. Do POP plans fall into this? Yes, a premium only plan is one of the 4 options of a Section 125 cafeteria plan. A POP is the same. Let's see. If a group does renew 7-1, they have a Section 125 in place. The dependents are not eligible 1-1. Correct. But when the group renews 7-1, yes, this should be an SEP for them because it is open enrollment for that group plan. I got an email today about the glitch. The new guidance will let a worker spouse independence give up cafeteria plan coverage and switch to ACA. Interesting. I'm not sure how that would work when the text of the piece in the Federal Register says it can't. Be cautious what you receive. But hey, if it happens, great. I don't know how they're going to do that without passing something that allows a violation to Section 125 rules. Oh my gosh, we are down to the wire. Let me go ahead and put this
You
up.
have 3 minutes, little girl.
Woo! Goodness. Man, there's so many moving pieces to this puzzle. You know, when you think about the different percentages out on the individual marketplace, oh my gosh, it's going to be crazy. Ronell, do let me know when you get the email about the broker education module coming out.
Yeah, I'll let you know what they say tomorrow, and then they should let me know when they expect it to happen, and then I'll let you know that and when it actually drops.
Yeah, for sure. Great point about the non-family member piece. Yes, someone is considered a non-family member if they cannot be claimed as a dependent on their parents' income tax or someone else's income tax. So, you know, for example, I can't claim my children on my income tax anymore. So it all kind of relates back to, can they be claimed as a dependent? If the answer is no, then they're considered a non-family member. My hope is that the new questions they ask and the business rules and logic that they update on the individual marketplace will dig into that and be prepared to ask those questions, which I think currently it asks if someone can be claimed as a dependent. We shall see. But again, keep in mind, employees who receive a qualifying offer that ticks off all the boxes cannot still, and in the future, go out to the marketplace to get a tax credit. This is for those folks where the spouse and dependents don't have coverage available elsewhere. And obviously it would cost an arm and a leg. Let's see. Oh my gosh, they're still coming in. Can the group just drop coverage for the whole group on January 1st so everyone can enroll in the ACA? Well, if the group has 50 or more full-time equivalents, they're required to provide group health care. If they are a small employer, they do not have to, by law, by ACA law, offer group benefits. So can they just drop the plan? They'd want to talk to their insurance carrier about that, but probably, I mean, it would be kind of no different than if they stop paying their premium. We all know if you don't pay your premium, regardless, the insurance company is going to drop you. Is it a good move to do that? I don't know. I don't know the situations, but I think that this alleviates the need for an employer to do that, because at the end of the day, employers are still struggling to get employees to come work for them, and benefits is still one of the top 5 reasons someone will go to work for someone else. Now at least we're allowing the spouse and dependents to have another opportunity or another outlet for insurance, and at a potentially discounted rate. And with that, oh my goodness, we're at 4 o'clock. I feel like we could talk for hours on this. Ronell, thank you so much for having me. Any final comments?
Just you're missing a number on your phone. So everybody's asking what your phone number actually is.
Oops, my
I
bad.
know you're not trying to be shady and miss one letter.
You
one
know,
number.
the last number is 855-742-7427, extension 209.
Thank you. Angie, you did a wonderful job. Thank you everyone for joining. I hope you got something out of this. You understand how important it is. As agents and brokers, we need to be there for all of our clients. We need to help them, whether they're in the group market or individual market. And HOP is here. We're here for you, and absolutely love you, want to support you. And if you're not a member and you join today, you will get the Monday morning news on Monday, and you'll hear what CMS said from tomorrow. So have a great day, and I look forward to hearing from you soon. Thank you, Angie.
Bye.
I'm gonna copy all your questions.
Ronell, are you going to post the video of it for us?
I am. I'm going to post the video and the slides.
Perfect. I figured as much, just wanted to make sure.
Yes, ma'am. Thank you.
Thanks.
Okay, bye-bye.